Hello, my name is Carl Barkemeyer, and I'm an attorney in Louisiana. I handle a lot of DWI cases, so I thought this would be a good presentation to kind of cover some of the defenses regarding DWI in Louisiana. Now keep in mind that this is not formal legal advice, so if you have a DWI charge, if you've been arrested, strongly recommend that you hire an attorney to help you through it. First of all, what's important to understand is that a police officer must have a reasonable basis to come in contact with the driver. In other words, he must be able to have probable cause to show that a traffic violation occurred in most instances. That's the first step. Another defense is that police officer must have probable cause to arrest. In other words, he must believe, he must have articulable facts and circumstances to show that he believes that the offender was operating a vehicle, one, and two, while under the influence of either alcohol, drugs, or a combination of both. So that's a very important basis that the police officer must cover. Other defenses in DWI cases may include fighting the field sobriety test. There are a few standard field sobriety tests that a police officer generally offers to the suspect, including the walk and turn, one leg stand, and horizontal gaze nystagmus test, which is commonly referred to as the pin test, when he takes a pin and runs it across your eyes and has you watch it. There are defenses to these. For example, sometimes the police officer doesn't always perform them correctly, or maybe he's not trained to perform them correctly. So these defenses must be explored. Also fighting the breathalyzer. Sometimes you can show that the breathalyzer wasn't maintained, the actual machine wasn't maintained, the operator wasn't certified, maybe the maintenance tech wasn't certified, and there's other various defenses to these as well. There are other defenses in felony DWI cases, and these may include fighting the actual prior DWI convictions. These are commonly referred to as predicates. The prosecutor in a multiple offender DWI case must prove that the offender committed DWI previously, and he does this by using court documents, fingerprints, transcripts. These are all important documents. They must all be in order to be able to prove the predicate. Otherwise, for example, you could get a DWI fourth offense knocked down to a DWI third offense. So these defenses make a big difference in the outcome of a case. So this has been a short, kind of general explanation of defenses for DWI in Louisiana. Like I said at the beginning of this video, if you have a charge, I definitely recommend that you hire an attorney.